Hello everyone, this case is regarding the taxability of lump sum amount received by an employee from Nepal Rashtra Bank. Further, we would also delve into the judicial mind of Justice Balaram K.C. where he advised the government regarding policy matters of taxing pension income. Employees of Nepal Rashtra Bank opted for voluntary retirement and received a lump sum amount equal to pension of 10 years as per Rule 57.5 of Nepal Rashtra Bank Employee Bylaws 2049. The amount received was shown as advance in the financial statement of NRB. Some amount was deducted and kept in account 219 as per employee-related liability. Moreover, in the profit and loss statement, the monthly pension amount is shown under employee expenses after deducting the same from advance account. The lump sum amount received by the employee was treated as employment income or retirement benefit as per Section 8 of Income Tax Act, and tax of 15% was deducted from it. The amount provisioned in account 219 was deposited in the tax office as tax liability of the employee. The applicants made the plea that as tax was deducted on lump sum amount, more tax was deducted than it would otherwise be deducted. Therefore, the advance amount should not be taxed on lump sum basis, rather it should be taxed on yearly basis. Further, Section 3 of Income Tax Act states that income is hereby imposed on and realized from every person as follows on each income year. Therefore, in line with Section 3 of Income Tax Act, income of 2 or more years cannot be clubbed in a single year and tax imposed thereon. Income tax for separate years should be calculated separately as per the spirit and intention of the Act. The advance amount of 10 years pension received by the applicant cannot be termed as income of a single year. Thereafter, the tax office countered by following contentions: that applicants have received a lump sum amount, however, they want to defer the payment of tax. The receipt of benefit and tax should coincide. Further, they quoted Section 22(2) of the Act, which states that an individual shall account for tax purposes on cash basis in calculating the individual's income from an employment or investment. Therefore, the lump sum amount should be taxed in the hands of the applicants on the basis of receipt of cash, and the Income Tax Act has not exempted such income. Therefore, such levy of tax is correct. Now, we move on to the decision made by the Supreme Court. In the present context, Section 8, Chapter 16, Chapter 17, Schedule 1, etc. of the Income Tax Act are relevant provisions. These provisions do not envision any situation and condition as has arisen as a result of Rule 57.5 of NRB Employee Bylaws 2049. Moreover, taxation power is an inherent authority of a sovereign nation. However, executives should not be granted discretionary powers regarding taxation matters. If laws have not been formulated regarding taxation, or if the law is silent, or if the law exists but is ambiguous, then taxation law should be interpreted in the favor of taxpayer and not the state. This is an accepted principle of interpretation of tax laws. Income tax of each year should be calculated as per the rates of taxation for each year. The act of NRB to deposit lump sum advance tax without any calculation and justification is not in accordance with the law. In the absence of any legal basis, the government cannot be nourished at the expense of the amount withheld from the applicants. Therefore, the illegal activity of the tax office and NRB is passed by the order of certiorari. After delivering the verdict, Justice Balaram K.C. made some remarks or suggestions to the government regarding taxation of pension income in Nepal. The court cannot question the legality of provision to tax pension as contained in Income Tax Act because it has been formulated in accordance with the articles of the Constitution. There is no doubt that the government can tax pension income. However, the government needs to do a policy recheck regarding taxing pension drawn by individuals holding public posts, constitutional functionaries and employees. Pension is provided in lieu of long length of service. Even though retired employees are politely said to be senior citizens, they are in fact old people. The Constitution has arrangements for protection and providing social security for elderly people, except for the old age allowance provided as per Section 3517 of Senior Citizen Act 2064. There are no legal arrangements for providing financial incentive to elderly citizens. The pension of retired individuals is not a bounty, but is provided in lieu of service, abiding by the code of conduct and dedication of prominent and productive years to the organization. Pension is not bounty but compensation provided for survival in the old age. Therefore, how can the amount which has been provided for survival be considered as income? In the country like ours, where social security net is absent, taxation of pension and welfare system are mutually exclusive terms. Therefore, is the system of taxing pension income by deeming it to be income a just system? The attention of Finance Minister is drawn in this regard.